नमस्कार, सूरज सिंह। भारत का संविधान, कॉन्स्टिट्यूशन ऑफ इंडिया, भारत के लोग, आर्टिकल 152 से आगे भारत के संविधान के बारे में विवरण बात करना। सबको क्या कहता है भारत का संविधान, व्हाट इट सेज, कॉन्स्टिट्यूशन ऑफ इंडिया, पीपल ऑफ इंडिया। वी आर गोइंग अहेड दिस। भारत के संविधान से आगे चलते हैं, बात करते हैं। आखिर ये बात हम रोज रोज क्यों कर रहे हैं? बात तो उठेगी ही, लेकिन जरूरी है समझना करना। भारत के संविधान को जानना बहुत जरूरी है भारत के नागरिकों को, क्योंकि संविधान खतरे में है। ऐसा लगता है कि सरकार द्वारा आवर कॉन्स्टिट्यूशन इज इन डेंजर। इट सीम्स टू बी एज पर effect of this new government, what you call fake government or alien government. In previous time of this government, they have only one agenda, and that is to eliminate Bharat Constitution of India or the Savidhan. Secret agenda is that, and that we have to fight with, and that is very important for the citizens of India who believe this country, who trust this country, who take this country religiously, and that is very important. It's not so easy because we cannot allow attack on our country. Constitution of India, we people of India having solemnly resolved to constitute India into a sovereign, socialist, secular, democratic republic and to secure to all its citizens justice, social, economic and political liberty of thought, expression, belief, faith and worship, equality of status and of opportunity, and to promote among them all fraternity, assuring dignity of individual and unity and integrity of nation. In our Constituent Assembly, this 26th day of November 1949, do hereby adopt, enact, and give to ourselves this Constitution. And then भारत का संविधान, हम भारत के लोग भारत को एक संपूर्ण प्रभुत्व संपन्न समाजवादी बंधुनिरपेक्ष लोकतंत्रात्मक गणराज्य बनाने के लिए तथा उसके समस्त नागरिकों को सामाजिक, आर्थिक और राजनीतिक न्याय, विचार, अभिव्यक्ति, विश्वास, धर्म और उपासना की स्वतंत्रता, प्रतिष्ठा और अवसर की समानता प्राप्त कराने के लिए तथा उन सब में व्यक्ति की गरिमा और राष्ट्र की एकता और अखंडता सुनिश्चित करने वाली बंधुता बढ़ाने के लिए दृढ़ संकल्प होकर अपनी संविधान सभा में आज तारीख 26 नवंबर 1949 ईस्वी को एत द्वारा इस संविधान को अंगीकृत, अधिनियमित और आत्म अर्पित करते हैं। मिति मार्गशीर्ष शुक्ला सप्तमी संवत 2006 विक्रमी को आपकी ज्ञान के लिए, आपके मेमोरी फ्रेश के लिए, आपको याद दिलाने के लिए ये प्रियम्बल संविधान क्या है, उसका कवर, उसकी आत्मा, उसका स्ट्रक्चर, उसका फंडामेंटलिज्म आपके सामने बताया जाता है। और संविधान का लिखा है आर्टिकल, पहले से जो पृष्ठभूमि पेज है जो सबसे शक्तिशाली है इस संविधान में, वो जगह प्रियम्बल, जिसके अंदर छुपा है सारा राज हमारी देश की जनता की शक्तियों का, सरकार की शक्तियों का, और जो भी हम हैं उसके बारे में हमने अपने लिए क्या किया, कैसे किया, एक बहुत बड़ा विवरण चित्रित अंदर किया गया है। तो आंख से नहीं दिखता लेकिन सोचने से दिखता है। संविधान के आर्टिकल्स बहुत हैं, लेकिन सबसे बड़ा एक तरह का जिसको आर्टिकल नहीं कहा जा सकता है, सुपर आर्टिकल कहा जा सकता है, जो हमारी क्षमता है, हमारी आइडेंटिफिकेशन है, हमारा परिचय है, वो है प्रियम्बल्स। Constitution of India is a very big document, but you cannot just consider it a document because there's a preamble for this document which structures this constitution, which reflects our structure, our society structure of public of this country, people of this country, because we ourselves have designed this and changed and enacted this and structured this and implemented this ourselves and still being implemented, and this has been with force since 1950 and still shall continue till centuries and millenniums to come if we people are set right and we don't have any differentiation among society, we don't take it into consideration of religions of faith or sects or caste, and we have to see that we people of India remain integrated and united for sake of our existence, for sake of Bharat, India, for its continuation of existence, and that is very significant factor for this constitution, because we have to understand first of all what this constitution is. It's not simply spelling of constitution, it's impact of constitution, it's the law, it's super law of this country, and so our own law is we are fully empowered as sovereign public of this country. We are kingship we are enjoying kingship as collective kingship in democratic way. And then socialist means we all are equal and we are all opportunities together, and whatever is there, secularism, socialism, all factors we are having, all parameters we are enjoying, and that is fortune that we are having this. We are not slave to any prime minister, we are not slave to any president, we are not slave to any king, or we are not slave to anyone else. We are slave to ourselves, we are masters to ourselves. Public is master to itself and public is slave to itself. Slave to itself means it has to live under umbrella of this constitution, and that is very important factor, significant factor we all have to understand. And we, as soon as we understand it, we will enjoy this constitution and will keep off from mind, because we have no way to change it. And those who think to change it and replace by something else, they are having foolishness degree in their mind. They cannot understand what our country is, what our society is, what our people are. They are just interested in dividing people of this country based on sex and based on religion and based on society and based on consideration of caste. Those people don't understand what we are. These people have never seen any struggle in life. Those people just want to rule this country for sake of ruling, and those people shall not be allowed, but they are having full power now. They are still interested. They just want to see they should be in power and no one else, but this is not going to happen. There should be clashes in this country. There should be status if this happens, if this constitution is broken or abrogated or demolished. Something will happen that is not tolerable, that shall not be tolerable, not acceptable at all. We don't want to see there is a civil fight among people, a civil dispute among people. That has to be avoided, and that these people are going to be responsible who are now in power. Particularly those people who come from RSS and now in BJP, this is mostly interested in that. They want to change this country's constitution. They want to change the structure of this constitution. They want to change everything of the constitution. They just want to have society. They think they have their own. They're not interested in the good future of this country. They're not interested in anything of this country. They're interested just to keep in power themselves. They're not interested in democracy. They're not interested in sovereign status. They're not interested in socialism. They're not interested in anything except that they want to keep this the power, because they are power-hungry people. They did nothing for this country during freedom fighting. They did nothing for this country after independence. They did nothing for this country in any way. They just want to loot this. Still, they are looting this country directly or indirectly. They are buying MLAs. They are buying the government. They are not interested in public. They are not interested in decision of public. They have been playing with EVMs, and they have played with EVMs. They have done every corrupt act and connivance with the election commission of this country in 2019. And it was not supposed to be. It was not supposed to be that way, but they did openly and people silent, because a few class of people, it's about 20% people who believe in this, that this constitution should be changed. They are all from upper class. They are from Pandits or Brahmins or Rajputs, what do you call them? They're all same 0.3-0.5% Pandits and 10 to 15% Rajputs. The 20 or 15% people want to rule this country of 85%, those who have been down to us for millenniums and centuries, but that's not going to happen, because people are sleeping. Of course, they are sleeping. They have been sleeping for long and centuries, but doesn't mean they will keep sleeping. We have to understand this very well. And as soon as we understand it, this is better for us. If BJP thinks or RSS think they can change this country's constitution, they are still in dilemma. They cannot understand what darkness and light is, because they are all darkness. That they are staying in darkness. They cannot also what light is. They cannot answer the constitution is. They don't know to analyze anything, because they are brainless people. They have insight and ambition, but they don't have minds. They think they can do whatever they want, but you see, it's too late. But they have to understand that nothing is permanent. It's very, they can come to government, they can do whatever they want, but they cannot change public. Public is public, and public knows everything. What Congress did, what BJP is doing, people know everything. They are doing very bad things. They are establishing very bad examples. They are buying MLAs and they are MPs, and they are calling them, you can see, patriots. How can you say somebody who buys MLA, public representative, MP, public representative, elected by people, how you can buy them for peace? And these people have been sold and been bought. Unfortunately, this happened. MLAs in many states have been bought, and MPs of Rajya Sabha have been bought, and MLAs have been bought, and these people are on sale. They have been sold and they've been bought. This is a very, you can say, a cruel situation. A fish in a market, a fish in a tank. That dirty fish it is. Means whatever government, whatever prime minister be there or a president there, whatever is happening is not acceptable. You cannot buy public representatives. Public representatives bought means Public is sold means public is sold, voter is sold, voter is bought. Can voter be bought? Can voter be sold? It's a question. If you buy a representative of public, you buy a whole constituency of public, this is not acceptable. Is voter on sale? This is a question to voter itself. Voter has to answer, is he on sale? If a representative who has been bought by some party and he comes back to election, someone else comes in, what public shall do? Public cannot kill that person. Public cannot call back that person. But this is happening. Public is fool because public elects such people. Public is fool because public elects criminals. 233 criminals sitting in Lok Sabha. Every time we have to say this because this is a very significant factor in our life. We are being ruled in Lok Sabha by 233, means about 43 to 45% of criminals sitting as MPs in our Lok Sabha. They are our super government, executive super government, and they are making our laws, and they shall be making our laws. How you think those laws shall be very good laws? You cannot have these criminals who work for society. You cannot kill, you cannot expect these people to work for you because they are criminals. They cannot think for society. They shall think for themselves because they spend crores of rupees in elections, and they came to be MPs in parliament. And voters were befooled by these people, and I don't know why voters voted them. Only voters know that God knows. How could our people elect criminals? This is a question. And well, it's very difficult to understand our people's mentality because we are used to flow in sentimental river. There's a sentimental river. If any prime minister, some prime minister, or even whatever party creates sentiment, emotionalized people, that person wins. And that happened many in recent past, and then you can say long back past, when Indira Gandhi did that in Garibi Hatao name, and these people did so many names. Now they are doing Article 370 name, they are doing Ram Mandir name, and they are doing all such kinds of vaccine, Achhe Din Aayenge, and our Vishwas, and all this bloody nonsense they are doing. They are doing nothing creative work in this country. They are only foolish people is to be fighting people from each and every angle. You may say I am criticizing. Yes, I am criticizing because I am a citizen of this country. I would absolutely try to criticize to an extent that is possible and feasible and rightly done, because this is my government, which I don't accept as a good government. I want a good person in government. I want a good prime minister, good president, but these are not. I want a good election commissioner. These are not. I am finding all institutions broken and demolished and dismantled, gradually being dismantled by this government, which is not acceptable. It is not acceptable. You are selling railways, you are planning to sell companies. How you can say you are good? You are rubbish because you are allowing loot to this country to your friends who are riches and commodities, but those people also shall get money from banks. Only this will, our people shall loot our money, and they will say this. Why? Why you cannot handle these companies? What problem do you have? You have 140 crores people in this country. You don't have engineers, you don't have skilled people, you don't have professors, you don't have doctors, you don't have PhDs to handle these companies. How shall those people handle these companies who are going to buy them? It's a question. Why they can handle, why state can handle? Because the state want to sleep, ministers want to sleep, they don't want to work. That's only criteria applicable here, because they are haram khor. They don't want to do work. That's what I used to say. Government should do that. It's a responsibility of government to keep public money safe. If government is so selling all these companies, government is criminal, I can say. Complete is a comprehensive body, executive criminal, because they are selling our work. All four fathers, our last prime minister, first prime minister, to all previous prime ministers, and British created this railway. Created many companies. We created many companies also, science companies, organizations, and you can say, for example, every scientific body, all were created, institutions were created, they are all trying to demolish them. This is not acceptable. This was discussed in last talks of these videos. I talked about our constitution, I talked about legislature, I talked about executive, I talked about judiciary. In details, I did not talk about judiciary because that is not linked to public. I talked about our fundamental rights. I talked about chapter 1, many chapters, many articles. Now I start about state because I had explained to you about union list, about state list, about concurrent list, about Panchayat Raj, about municipalities, and now we are going to start the state. It's very important because we have to know about the state also. The state is a very important factor in our life. That is in Article 152 onwards, and we have to see that. That is very important point here. We should understand that what is it is actually, particularly those youth who don't know about this, they should know about this, because after all, this is our power. This is our state. This is our, you can say, our state, our personal state. It's not a state of government, it's a state of public, and public has to deal particularly state themselves. No one comes there, no MP comes there, no legislator comes there. People have to deal with the state departments themselves directly, and municipalities themselves directly, and panchayats directly. That is very important to know from that point of view. How can you deal with those people? If we can't deal with those people successfully, then how can we succeed? We cannot do our rights, we cannot serve ourselves, and then these people will act criminally on us, and they will loot us, and they are looting us. We have to understand what state is, what center is. All we have to understand, and we have to understand only by from constitution. That is the only document that can tell us what we are and what we have to do, what are our rights and what are not our rights. So we have to start now about this. What is state? Part 6, this is what is a state in constitution. This is article 152, that definition. Chapter 1 general, this is regarding state, and this says 52 152. In this part, unless context otherwise requires, expression state does not include state of Jammu and Kashmir. Well, that is very general. Chapter 2 in this says executive. Governor is executive. 153 article, there shall be a governor for each state, provided that nothing in this article shall prevent appointment of same person as governor for 2 or more states. Then it says 154, executive power of states. 151 says executive power of state shall be vested in governor and shall be exercised by him either directly or through officers subordinate to him in accordance with constitution. Then it says number 2, nothing in this article shall be deemed to transfer to governor any functions conferred by any existing law on any other authority, or B, prevent parliament or legislature of state from conferring by law functions on any authority subordinate to governor. 155 article says appointment of governor. Governor of the state shall be appointed by president by warrant under his hand and seal. Terms of office of governor. Governor shall hold office during pleasure of president. Then if you go to number 2, it says governor may be writing. Governor may by writing under his hand address to president resign his office. Then 3, subject to foregoing provisions of this article, a governor shall hold office for a term of 5 years from date on which he enters upon his office, provided that a governor shall, notwithstanding expiration of his term, continue to hold office until his successor enters upon his office. 157 article says no person shall be eligible for appointment as governor unless he is a citizen of this country, India, and has completed the age of 35 years. And then 158 says 158(1), governor shall not be member of either House of Parliament or of a House of Legislature of any state specified in this first schedule, and is a member of either House of Parliament or of a House of Legislature of any such state. The appointed governor shall be deemed to have vacated his seat in that house on day on which he enters upon his office as governor. Governor shall not hold office any other office of profit. Then it is governor shall be entitled without payment of rent to use his official residence, and shall be also entitled to such emoluments, allowances, and privileges as may be determined by Parliament, by law, and until provision in that behalf is so made, such emoluments, allowances, and privileges as are specified in second schedule. Then it's 3A, where same person is appointed as governor of 2 or more states. Emoluments and allowances payable to governor shall be allocated among states of such proportion as president may be by order determined. The 4, emoluments and allowances of governor shall not be diminished during his term of office. 159, every governor and every person discharging functions of governor shall, before entering upon his office, make and subscribe in presence of Chief Justice of High Court exercising jurisdiction in relation to state, on his absence, senior-most judge of that court available, an oath or affirmation in following forms, that is to say, I, A, B, solemnly affirm that I will faithfully execute office of governor or discharge functions of governor of name of state, and will, best of my ability, preserve, protect, and defend Constitution and law, and that I will devote myself to service and well-being of people of name of state. Then Article 137, discharge of functions of governor in certain contingencies. President may take such provision as think fit for discharge of the function of governor of a state in any contingencies not provided for in this chapter. 161. Governor of a state shall have power to grant pardons, reprieves, respites, or remissions of punishment to suspend, remit, or commute sentence of any person convicted of any offence against any law relating to a matter to which executive power of state extends. 162. Subject to provisions of this Constitution, executive power of a state shall extend to matters with respect to which legislature of a state has power to make laws, provided that in any matter with respect to which legislature of a state or parliament have powers to make laws, executive power of state shall be subject to and limited by executive power expressly conferred by this Constitution or by any law made by Parliament upon Union or authorities thereof. Then Council of Ministers, Article 163(1), there shall be a Council of Ministers with Chief Minister at head to aid and advise Governor in exercise of functions, except in so far as he is by or under this Constitution required to exercise these functions or any of them in his discretion. So, if any question arises whether any matter is or is not a matter of respects which governor is by or under this Constitution required to act in his discretion, decision of governor in his discretion shall be final, and validity of anything done by governor shall not be called in question on ground that he ought or ought not to have acted in this discretion. 3. Question whether any and of what, or if so what advice was then tendered by ministers to governor shall not be inquired into any court. Article 164(1). Chief Minister shall be appointed by governor and other ministers shall be appointed by governor on advice of Chief Minister, and ministers shall hold office during Minister shall hold office during pleasure of governor, provided that in the state of Chhattisgarh, Jharkhand, Madhya Pradesh, and Orissa there shall be a minister in charge of tribal welfare, who may in addition be in charge of welfare of scheduled classes and backward classes or any other work. 1A. Total number of ministers, including Chief Minister, in Council of Ministers in a state shall not exceed 15% of total number of members of legislative assemblies of that state, provided that number of ministers, including Chief Minister in a state, shall not be less than 12. Provided further that where total number of ministers, including Chief Minister in Council of Ministers in any state at commencement of the Constitution 19 First Amendment Act 2003 exceeds said 15% or numbers specified in first provision, as the case may be, then total number of ministers in that state shall be brought in conformity with provisions of this clause within 6 months from such date as President may by public notification appoint. 1B. A member of Legislative Assembly of a state or either House of Legislature or of a state having legislative council belonging to any political party who is disqualified for being a member of that House under paragraph 2 of 10th schedule shall also be disqualified to be appointed as a minister under clause 1 for duration of period commencing from date of his disqualification till date on which term of office as such member would expire, or where contest any election in legislative assembly of a state or either house of a legislature of a state having legislative council, as case may be, before expiry of such period till date on which he is declared elected, whichever is earlier. 2. Council of Ministers shall be collectively responsible to Legislative Assembly of State. Before a minister enters upon his office, the governor shall administer to him oath of office and of secrecy according to forms set out for purpose to in third schedule. A minister who is for a period of 6 consecutive months is not a member of legislature of state shall at expiration of that period cease to be a minister. Salaries and allowances of ministers shall be such as legislature of state may from time to time by law determine, and until legislature of state so determines, shall be as specified in second schedule. Advocate General for State 165(1). Governor of each state shall appoint a person who is qualified to be appointed a judge of a high court or advocate general for state. It shall be duty of advocate general to give advice to government of state upon such legal matters and to perform such other duties of a legal character as may from time to time be referred or assigned to him by governor and to discharge functions conferred on him by or under Constitution or any other law for time being in force. Advocate General shall hold office during pleasure of Governor and shall receive such a remuneration as Governor may determine. Conduct of government is Article 166(1). Executive action of government of a state shall be expressed to be taken in name of a governor. Orders and other instruments made and executed in name of governor shall be authenticated in such manner as may be specified in rules to be made by governor, and validity of an order or instrument which is so authenticated shall not be called in question on ground that it is not an order or instrument made or executed by a governor. 3. Governor shall make rules for more convenient transactions of business of government of state and for allocation among ministers of business said business insofar as it is not business with respect to which governor is by or under his constitution required to act in his discretion. It shall be duty of chief minister of each state to communicate to governor of state all decisions of council of ministers relating to administration of affairs of state and proposals for legislation, b. to furnish such information relating to administration of affairs of state and proposal for legislation as governor may call for. C. If governor requires to submit for consideration of council of ministers any matter on which a decision has been taken by minister but which has not been considered by council. Then chapter 3, state legislature general. Article 168(1). For every state there shall be a legislature which shall consist of governor, and in a state of Andhra Pradesh, Bihar, Madhya Pradesh, Maharashtra, Karnataka and Uttar Pradesh 2 houses, in other states 1 house. Where there are 2 houses of legislature of a state, one shall be known as legislative council and other legislative assembly, and where there is only 1 house, it shall be known as legislative assembly. 169(1). Notwithstanding anything in Article 168, Parliament may by law provide for abolition of legislative council of a state having such a council, or for creation of such a council in a state having no such council, if legislative assembly of state passes a resolution to that effect by a majority of total membership of assembly and by a majority of not less than 2/3 of members of assembly present and voting. Any law referred to in clause 1 shall contain such provisions for amendment of this constitution as may be necessary to give effect to provisions of law, and may also contain such supplemental, incidental and consequential provisions of parliament may deem necessary. 3. No such law as aforesaid shall be deemed to be an amendment of this constitution for purpose of Article 368, 170, 171, composition of legislative assemblies. Subject to provisions of Article 333, legislative assembly of each state shall consist of not more than 500 and not less than 60 members chosen by direct election from territorial constituencies in a state. 2. For purposes of clause 1, each state shall be divided into territorial constituencies in such a manner that ratio between population of each constituency and number of seats allotted to it shall be so far as practicable same throughout state. Explanation. In this clause, expression population means population as ascertained at last precedent census of which election figures have been published. Article 170 to 171, that is Part 6. Provided a reference in this explanation to last preceding census of which relative figures have been published shall, until relevant figures for first census taken after years 2026 have been published, be constituted as a reference to census 2001. Upon completion of each census, total number of seats in legislative assemblies of each state and division of each state into territorial constituencies shall be readjusted by such authority and in such manner as Parliament may law determined, provided that such adjustment shall not affect representation in the Legislative Assembly until dissolution of then existing assembly. Provided further that such readjustments shall take effect from such date as President may by order specify, and until such adjustment takes effect, any election to Legislative Assembly may be held on basis of territorial constituencies existing before such readjustment. Provided also that until relevant figures for first census taken after year 2026 have been published, it shall not be necessary to readjust. A1. Total number of seats in Legislative Assembly of each state as readjusted on basis of Census 1971. A division of such a state into territorial constituencies as may be readjusted on basis of census. Article 171. Article 171. 1. Total number of members in Legislative Council of a state having such council shall not exceed 1/3 of total number of members in Legislative Assembly of that state, provided that total number of members in Legislative Councils of a state shall in no case be less than 40. Until Parliament by law otherwise provides, composition of Legislative Council of a state shall be as provided in Clause 3 of total number of members of Legislative Council of a state. Okay. That is important. A. As many as may be 1/3 shall be elected by electorates consisting of members of municipalities, district boards, and such other local authorities in a state as Parliament may by law specify. As nearly as may be 1/12 shall be elected by electorate consisting of persons residing in state who have been for at least 3 years graduates of any university in territory of India or have been for at least 3 years in possession of qualifications prescribed by or under any law made by Parliament as equivalent to that of a graduate of any such university. As nearly as may be 1/12 shall be elected by electorates consisting of persons who have been for at least 3 years engaged in teaching in such educational institutions within a state not lower in standard than that of secondary school as may be prescribed by or under any law made by Parliament. D. As nearly as may be 1/3 shall be elected by members of Legislative Assembly of state from amongst persons who are not members of Assembly. E. Remainder shall be nominated by Governor in accordance with provisions and clause. Members to be elected under subclause and of clause shall be chosen in such territorial constituencies as may be prescribed by or under any law made by Parliament and elections under said subclauses and under subclause D of said clause shall be held in accordance with system of proportional representation by means of single transferable vote. Members to be nominated by Governor under subclause C of clause 3, clause E of clause 3 shall consist of persons having special knowledge or practical experience in respect of such matters following as following, namely literature, science, art, cooperative movement, and social welfare, social service. 172, Article 172.1. Every legislative assembly of every state, unless not dissolved, shall continue for 5 years from the appointed for first meeting and no longer, and expiration of said period of 5 years shall operate as a dissolution of assembly, provided that said period may, while a proclamation of emergency is in operation, be extended by Parliament by law for a period not exceeding 1 year at a time and not exceeding one in any one case beyond a period of 6 months after prorogation has ceased to operate. Third, legislative council of a state shall not be subject to dissolution, but as nearly as possible, 1/3 of members thereof shall retire as soon as may be on expiration of every second year, in accordance with provisions made in that behalf by Parliament by law. 173. A person shall not be qualified to be chosen to fill a seat in the legislature of a state unless he is a citizen of India and makes and subscribes before some person authorized in that behalf by Election Commission as oath affirmation according to form set out for purpose in this schedule. And third schedule. B is in the case of a seat of legislative assembly not less than 25 years of age, and in case of seat of legislative council not less than 30 years of age, and C possesses such other qualifications as may be prescribed in that by behalf by or under law made by Parliament. Article 174.1. Governor shall from time to time summon house or each house of legislature of state to meet at such time and place as he thinks fit, but 6 months shall not intervene between last sitting in one session and that appointed for its best sitting in next session. Governor may from time to time prorogue house or either house, dissolve legislative assembly. 175.1. Governor may address legislative assembly or in case of a state having a legislative council, either house of legislature of state or both houses assembled together, and may for that purpose require attention of members. 2. Governor may send messages to house or houses of legislature of state whether with respect to bill then pending in legislature or otherwise house to which any messages is sent shall with all convenient dispatch consider any matter required by message to be taken into consideration. 176.1. At commencement of first session after each general election to legislative assembly, and at commencement of first session of each year, governor shall address legislative assembly or in case of a state having a legislative council, both houses assembled together and inform legislature of the causes of its summons. Provision shall be made by rules regulating procedure of house or either house for allotment of time for discussions of matters referred to in such address. 177. Rights of ministers and advocates general as respects house. Every minister and advocate general for such state shall have right to speak in and otherwise to take part in proceedings of Legislative Assembly of a state, or in case of state having a Legislative Council, both houses, and to speak in and otherwise to take part in proceedings of any committees of legislature of which he may be named a member, but shall not by virtue of this article be entitled to vote. Office of State Legislature, Article 178. Every legislative assembly of a state shall, as soon as may be, choose two members of assembly to be respectively speaker and deputy speaker thereof, and so often as office of speaker or deputy speaker becomes vacant, assembly shall choose another member to be speaker or deputy speaker as case may be. Article 179. A member holding office as Speaker or Deputy Speaker of an Assembly shall vacate his office if he ceases to be a member of the Assembly. B. May at any time, by writing under his hand, address if such member is Speaker through Deputy Speaker, and if such member is Deputy Speaker, the Speaker resigns his office, and C. May be removed from his office by a resolution of assembly passed by a majority of all the members of assembly, provided that no resolution for purpose of clause C shall be moved unless at least 14 days notice has been ignored ignored. Okay. Maybe a root of office. Okay. Now. Provided that no resolution for purpose of clause C shall be moved unless at least 14 days notice has been given of intention to move resolution, provided further that whenever the assembly of resolution, the speaker shall not vacate his office until immediate before first meeting of assembly after resolution. Article 180. While office of speaker is vacant, duties of office shall be performed by deputy speaker, or if office of deputy speaker is also vacant, by such member of assembly as governor may appoint for purpose. During absence of speaker from sitting of assembly, deputy speaker, or if he is also absent, such person as may be determined by rules of procedures of assembly, or if not, such person is present, such other person as may be determined by assembly shall act as speaker. 181. Speaker, deputy speaker not to preside while resolution for his removal from office is under consideration. Article 181. At any sitting in legislative assembly, while any resolution for removal of a speaker from his office is under consideration, the speaker, or while any resolution for removal of deputy speaker from his office is under consideration, deputy speaker shall not, though he is present, preside, and provisions of clause 2 of article 180 shall apply in relation to every such sitting as they applied in relation to sitting from which speaker, or as case may be, deputy speaker is absent. 2. A speaker shall have right to speak in otherwise to take part in proceedings of legislative assembly while any resolution for his removal from office is under consideration in assembly, and shall notwithstand anything in article 189 be entitled to vote only in first instance on such resolution or on each other member during such proceedings, but not in case of an equality of votes. 182. Legislative Council of every state having such council shall, as soon as may be, choose two members of council to be respectively chairman and deputy chairman thereof, and so often as office of chairman or deputy chairman becomes vacant. Council shall choose another member to be chairman of the or to be chairman as case may be. 183. A member holding office of chairman or deputy chairman of a state of a legislative council shall vacate his office if he ceases to be a member of council, may be at any time by writing under his hand addressed if such member is a chairman to deputy chairman, and if such a member is a deputy chairman to chairman, resign his office, and C, may be removed from his office by a resolution of council passed by a majority of all then members of council, provided that no resolution for purpose of clause C shall be moved unless at least 14 days notice has been given of intention to move resolutions. Article 184. Article 184.1. Let me see how many minutes have elapsed. That's also important to see all the time. 46 minutes. Okay, we can continue. Article 184. While office of chairman is vacant, duties of office shall be performed by deputy chairman, or if office of deputy chairman is also vacant, by such a member of council as governor may appoint for purpose. 2. During absence of chairman from any sitting of council, deputy chairman, or if he is also absent, such person as may be determined by rules of procedures of council, or if no such person is present, such other persons as may be determined by council shall act as chairman. 185. At any sitting of legislative council, while any resolution for removal of chairman from his office is under consideration, chairman, or while any resolution for removal of deputy chairman from his office is under consideration, deputy chairman shall not, though he is present, preside, and provisions of clause 2 of article 184 shall apply in relation to every such sitting as they apply in relation to a sitting from which chairman, or as case may be, deputy chairman is absent. 2. Chairman shall have a right to speak and otherwise to take part in proceedings of legislative council while any resolution for his removal from office is under consideration in council, and such, notwithstanding anything in this article 99, we are entitled to vote only in first instance on such resolution or any other matter during such proceedings, but not in case of an equality or worse. 186. There shall be paid to Speaker and Deputy Speaker, Legislative Assembly, and the Chairman of Deputy Chairman of Legislative Council such salaries and allowances that may be respectively fixed by legislation of a state by law, and until provisions on that behalf is so made, such salaries and allowances as are specified in second schedule. 87. 187. House or each house of legislative of a state shall have a separate secretarial staff, provided that nothing in this clause shall, in a case of a legislature or of a state having a legislative council, be constituted as preventing creation of post common to both houses of such legislature. So, legislature of a state may be by law regulate recruitment and conditions of service of persons appointed to secretarial staff of house of legitimate of state. Until provision is made by legislature of state under clause 2, government may, after consultation, the Speaker of Legislative Assembly or Chairman of Legislative Council, as case may be, make rules regulating recruitment and conditions of service of persons appointed to secretarial staff of assembly or council, and any rule so made shall have effect subject to provisions of any law made under said clause. Conduct of business. So we have come to conduct of business, which is going to have Article 188 to how much it is about then the three qualification members, and then it is so it is many more. I think it's many more. Yes. So we say 188. Yes. Every member of Legislative Assembly or Legislative Council of a state shall, before taking his seat, make and subscribe before governor or some person appointed in that behalf by him an oath of formation according to form set out for purpose of third schedule. 189. Same as otherwise provided in the Constitution, all questions at any sitting of House of Legislature of the state shall be determined by a majority of votes of members present and voting, others than Speaker or Chairman of persons acting such. The Speaker or Chairman of a person or a person acting as such shall not vote in first instance, but shall have exercise of casting vote in the case of equality of powers, equality of voters. The House of Legislature of a state shall have power to act in notwithstanding any vacancy in membership thereof, and any proceedings in legislature of a state shall be valid notwithstanding that it is discovered subsequently that some person who was not entirely so to do sat or voted or otherwise took part in proceedings. Until legislature of a state by law otherwise provides a quorum to constitute a meeting of the House of Legislature of a state shall be 10 members or 1/10 of total number of members of the House, whichever is greater. 4. If at any time during a meeting of Legislative Assembly or Legislature Council of State, therefore there is no quorum at it, it shall be duty of Speaker to or Chairman for person attending persons acting as such, either to adjourn House or to suspend meeting until there is a quorum. Disqualification of members. 190. No person shall be member of both houses of legislature of a state. Provision shall be made by a legislature of a state by law for vacation by a person who is chosen member of both houses of seat in one house or other. No person shall be member of legislature of two or more states specified in first schedule, and if a person is chosen a member of legislature of two or more such states, then at expiration of such period as may be specified in rules made by President, that person's seat in legislature of all such states shall become vacant unless he has previously resigned and okay. I will repeat again. No person shall be a member of a legislature of two houses, two or more states specified in first schedule, and if a person is chosen member of legislature of two or more such states, then at expiration of such period as may be specified in rules made by President, that person's seat in legislature of all such states shall become a vacant unless he has previously resigned his seat in legislature of all but one of states. If a member of a house or of legislature of a state if a member of a house of legislature of a state becomes subject to any of these qualifications mentioned in clause 1 and 2, resign his seat by writing under his hand address to speaker or chairman as case may be, and his resignation is accepted by Speaker or Chairman as case may be. His seat shall thereupon become vacant, provided that in case of any resignation referred to in subclause B from information received or otherwise, and after making such inquiry as things fit, Speaker or Chairman as case may be is satisfied that such resignation is paid. Hmm. As case may be satisfied that such resignation is not voluntary or genuine, he shall not accept such resignation, I repeat, provided that in case of any resignation referred to in subclause B, if from information received or otherwise, and after making such inquiry as he thinks fit, the Speaker or Chairman, as case may be, is satisfied that such resignation is not voluntary or genuine, he shall not accept such resignation. If for a period of 60 days a member of a House of Legislature of a state is without permission of House absent from all meeting thereof, House may declare his seat vacant, provided that in computing said period of 60 days, no account shall be taken of any period during which House is prorogued or is adjourned for more than 4 consecutive days. 191 article. A person shall be disqualified for being chosen as and for being a member of Legislative Assembly or Legislative Council of a state if he holds an high office of profit under Government of India or Government of any state specified in first schedule, other than when office declared by Legislature of state by law, not to a disqualified holder. If he is of unsound mind and stands so declared by competent court, if he is an undischarged mourner, insolvent, if he is not a citizen of India or has voluntarily acquired citizenship of a foreign state or is under any acknowledgement of allegiance, if he is an undischarged insolvent, if he is not a citizen of India and has voluntarily acquired citizenship of foreign state or is under any acknowledgement of allegiance or adherence to a foreign state, if he is so disqualified by or under any law made by Parliament, explanation for purpose of this clause, a person shall not be deemed to hold an office of profit under Government of India or Government or any state specified for schedule by reason only that he is a minister either for union or for such state. A person shall be disqualified for being a member of Legislative Assembly or Legislative Council of a state if he is disqualified under tenants. Okay. If any question arises, if a person shall be disqualified for being a member of Legislative Assembly or Legislative Council of a state, if he is so disqualified under 10th schedule, if any question arises as to whether a member of a House of Legislature or state has become subject to any of disqualifications mentioned in clause 1 of Article 191, question shall be referred for decision of governor and his decision shall be final. Before giving any decision on any such question, the governor shall obtain opinion of election commission and shall act accordingly to such opinion. 193. If a person sits or votes as a member of Legislative Assembly or Legislative Council of a state before he has complied with requirements of Article 188, or when he knows that he is not qualified or that he is disqualified for membership thereof, or that he is prohibited from so doing by provision of any law made by Parliament or legalized or legislature of a state, he shall be liable to in respect of each day on which He so sits or votes to penalty of 500 rupees to recovery God as a debt due to state. Powers, privileges and immunities of state legislature and their members, Article 194. It's only 1 hour and our chapter is not over. I think I will complete in English and leave it in Hindi or separately. What to do, I don't know. Anyway, we continue. 194. Powers, privileges. Okay. Will say one, subject to provisions of Constitution and to rules and standing orders regulating procedures of legislature, there shall be freedom of speech in legislature of the state. No member of legislature of a state shall be liable to any proceedings in any court in respect of anything said or any vote given by him in legislature or any committee thereof, and no person shall be so liable in respect of publication by or under authority of a house of such legislature of any report, paper, voted, votes or proceedings. In other respects, the powers, privileges, and immunities of a house of legislature of a state and of members and committee of a house or such legislature shall be such as may from time to time be defined by legislature by law, and until so defined shall be those of that house and of members and committees immediately before coming into force. Section 26 of Constitution. 44 Amendment Day Act 88. Provisions of clause 1, 2 and 3 shall apply in relation to persons who by virtue of this constitution have right to speak in otherwise to take part in proceedings of a house of legislature of a state or any committee thereof as they apply in relation to members of that legislature. 195. Members of Legislative Assembly and Legislative Council of a state shall be entitled to receive such salaries and allowances may from time to time, as may from time to time be determined by legislature of a state by law, and until provision in that respect so made. Salaries and allowances at such rates and upon such conditions as were immediately before commencement of this constitution applicable in case of members of legislative assembly of corresponding province. Legislative procedures. So legislative procedure is coming now. Well, 196.1 subject to provisions of Article 198 and 207, the respect to money bills and other financial bills, a bill may originate in either house of a legislature of a state which has legislative council. 2. Subject to provisions of Article 197 and 198, a bill shall not be deemed to have been passed by houses of legislature of a state having a legislative council unless it has been agreed to by both houses either without amendment or with such amendment only as are agreed to by both houses. 3. A bill pending in legislature of a state shall not lapse by reasons of propagation of a house or house thereof. A bill pending in legislative council of a state which has not been passed by legislative assembly shall not lapse on a dissolution of assembly. A bill which is pending in legislative assembly of a state or which having been passed by legislative assembly is pending for legislation council shall lapse on dissolution of assembly legislative council. 197. If after a bill has been passed by legislative assembly of a state having a legislative council and transmitted to legislative council, the bill is rejected by council or more than 3 months elapse from the date on which bill is laid before council without bill being passed or bill is passed by council with amendments to which legislative assembly does not agree. The legislative assembly does not agree on the result. Legislative assembly may, subject to rule regulating its procedure, pass bill agreed to in same or in any subsequent session with or without such amendments, if any, as have been made, suggested or agreed to by legislative council, and then transit bill so passed to Legislative Council. If after a bill has been so passed for the second time by Legislative Assembly and transmitted to Legislative Council, bill is rejected by Council or more than 1 month lapses from date on which bill is laid before Council without bill being passed by it, or bill is passed by Council with amendments to which Legislative Assembly does not agree. Bill shall be deemed to have been passed by houses of legislature of a state in form in which it was passed by Legislative Assembly for second time with such amendments, or if any, as have been made or suggested by Legislative Council and agreed to by Legislative Assembly. Nothing in this article shall apply to money bill. 198. A money bill shall not be introduced in Legislative Council. After a money bill has been passed by Legislative Assembly of a state having a Legislative Council, it shall be transmitted to Legislative Council for its recommendations, and Legislative Council shall within a period of 14 days from the day of receipt for a bill increase debate of the receipt of bill, which a period of 14 days from date of its receipt of bill, return bill to Legislative Assembly with recommendations, and Legislative Assembly may thereupon either accept all or any of the recommendations of Legislative Council. If Legislative Assembly accepts any of recommendations of Legislative Council, money bill shall be deemed to have been passed by both houses with amendments recommended by Legislative Council and accepted by Legislative Assembly. If Legislative Assembly does not accept any of recommendations of Legislative Council, money bill shall be deemed to have been passed by both houses in form of which it was passed by Legislative Assembly without any of amendments recommended by Legislative Council. If a money bill passed by Legislative Assembly and transmitted to Legislative Council for recommendations is not returned to Legislative Assembly within said period of 14 days, it shall be deemed to have been passed by both houses at expiration of said period, and in said period. In 14 days, it shall be deemed to have been passed by both houses at expiration of the said period in form of which it was passed by Legislative Assembly. 199. For purpose of this chapter, a bill shall be deemed to be a money bill if it contains only provisions dealing with all or any of following matters: imposition, abolition, remission, alteration, or regulation of any tax, regulation of borrowing of money or giving of any guarantee by state, or amendment of law with respect to any financial obligations under or be undertaken by state, custody of consolidated fund or contingency fund of state, payment of money into or by withdrawal of money from any such fund, appropriation, sorry, okay, again. Yes, custody of consolidated fund or contingency fund of state, payment of money into withdrawal of monies from any such fund, appropriation of monies out of consolidated fund of state, the decision declaring of any expenditure to expenditure charged on consolidated fund of state, or increasing of amount of any such expenditure. Receipt of money can account of consolidated fund of state or public account of state, or custody or issue of such money, or any material incidental to any of materials specified in such clauses. A brief shall be deemed to be a money bill. Bill shall not be deemed to a money bill by reason only that it provides for imposition of fines or other pecuniary penalties, or for demand or payment of fees for licenses or fees for services rendered by reason that it provides for services rendered, or by reason that it provides for imposition, abolition, remission, alteration, or revolution of tax by any local authority or body for local purpose. If any question arises whether a bill introduced in the legislature of a state which has the legislative council is a money bill or it's not, decision of Speaker of Legislative Assembly of such a state thereof shall be taken. Shall be final. There shall be endorsed on every money bill when it is transmitted to Legislative Council under Article 198 and when it is presented to Governor for assent under Article 200, a certificate of Speaker of Legislative Assembly signed by him that it is a money bill. 200. Let me see if we can take 200 now. Let us hold this this for time being. Let us see, 5 minutes I hold this. I have to put some food for. I'm just coming. 5 minutes. Sorry for the late. 5 minutes I was there for some birds, the food. Well, let's continue. Okay, we'll continue this article. This is 200. When a bill has been passed by Legislative Assembly of a state, or in case of a state having a Legislative Council, has been passed by both houses of legislature of state, it shall be presented to Governor, and the Governor shall declare either that he assents to the bill, or that he withholds assent therefrom, or that reserves the bill for consideration of President, provided that Governor may, as soon as possible after presentation to him of bill for assent, returns bill if it is not a money bill, together with message requesting that House or Houses reconsider bill or any specified provisions thereof, and in particular will consider desirability of introduction any such amendments as he may recommend in his message, and when a bill is so returned, House or Houses shall reconsider bill accordingly, and if bill is passed again by Houses or Houses with or without amendments and presented to Governor for assent, the Governor shall not withhold assent therefrom. Provided further that Governor shall not assent to but shall reserve for consideration of President any bill which in opinion of Governor worked, if it becomes law, so derogate from powers of High Court as to endanger position which that court is by this Constitution designed to fill. Article 201. When a bill is reserved by Governor for consideration of President, President shall declare either that he assents the bill or that it withholds assent therefrom. Provided that where the bill is not a money bill, President may direct Governor to return bill to House, or as case may be, Houses of Legislature of state together with such a message as is mentioned in the first provision to Article 200, and when a bill is so returned, houses shall reconsider in accordance with the period of 6 months from date of receipt of such message, and it is again passed by houses with or without amendments, it shall be presented again to President for his consideration. Procedure in financial matters. 202, Article 202. Now, Article 202, yes, it is again 1. Governor shall, in respect of financial year cost to be laid before houses of legislature of state, a statement of estimated receipt and expenditure of state for that year in part referred to as annual financial statement. This is okay. Estimated expenditure embodied in annual financial statement shall show separately sums required to meet expenditure prescribed by Constitution, expenditure charged upon consolidated fund of state, and sums required to meet other expenditure proposed to be made from consolidated fund of state, and shall distinguish the expenditure on revenue account from other expenditure. Following expenditure shall be expenditure charged on consolidated fund of each state, emoluments and allowances of governor, and other expenditure relating to his office, salaries and allowances of speaker and deputy speaker of legislative assembly, and in case of state having a legislative council, also of a chairman and deputy chairman of legislative council, debt charges for which state is liable including interest, sinking fund charges and redemption charges, and other expenditure relating to raising of loans and service and redemption of debt, expenditure in respect of salaries and allowances of judges of any high court, any sums required to satisfy judgment, decree, or award of any court or arbitral tribunal, any other expenditure declared by Constitution or by legislature of state by a law to be charged. Article 203, procedure and legislation with respect to estimates. So much of estimates as relates to expenditure charged upon consolidated fund of its state shall not be submitted to vote of legislature assembly, but nothing in this clause shall be construed as preventing discussion in legislature of any of these estimates. So much of said estimates are related to other expenditures shall be submitted in forms of demand for grants to legislative assembly, and legislative assembly shall have power to assent or to refuse to assent to any demand or to assent to any demand subject to reduction of amount specified therein. No demand for a grant shall be made except on recommendation of governor. Article 204, as soon as may be after grants under Article 203 have been made by assembly, there shall be introduced a bill to provide for appropriation out of consolidated fund of state of all monies required to meet grants so made by assembly, and expenditure charged on consolidated fund of state but not exceeding in any case amount shown in statement previously made before House of Houses. No amount shall be proposed to any such bill in houses or either house of legislature of state which will have effect of varying amount of altering destination of any grant or grant so made, or of varying amount of any expenditure charged on consolidated fund of a state, and decision of person presiding as to whether or an amendment is inadmissible under this clause shall be final. Subject to provisions of Article 205 and 206, no money shall be withdrawn from consolidated fund of state except under appropriation made by law passed in accordance with provisions of this article. Article 205, governor shall, if amount authorized by any law made in accordance with provisions of Article 204 to be expended for particular service for current financial year is found to be insufficient for purposes of that year, or when a need has arisen during current financial year for supplementary or additional expenditure upon some new services not contemplated in annual financial statement for that year, or if any money has been spent on any service during a financial year in excess of amount granted for that service and for that year, cause to be laid before house or houses of legislature of the state another statement showing estimated amount of that expenditure, or cause to be presented to legislative assembly of the state a demand for such excess or case may be. 2. Provisions of Article 203, 202, 203 and 204 shall have effect in relation to any state such statement and expenditure on demand, and also to any law to be made authorizing appropriation of monies out of consolidated fund of state to meet such expenditure or grant in respect of such demand as they have effects in relation to annual financial statement and expenditure mentioned therein, or to a demand for a grant and law to be made for authorization of appropriation of monies out of consolidated fund or state to meet such expenditure or grant. Vote on account, vote on credit and exceptional grants. Article 206. Notwithstanding anything in foregoing provisions of this chapter, Legislative Assembly of a state shall have power: A. To make any grant in advance in respect of estimated expenditure for a part of any financial year, pending completion of procedure prescribed in Article 203 for voting of such grant and passing of law in accordance with provisions of Article 204 in relation to their expenditure. B. To make a grant for meeting an unexpected demand upon resources of state when one account of magnitude or indefinite charges of service demand cannot be stated. Indefinite character, I read again. To make grant for meeting an unexpected demand upon resources of state when account of magnitude or indefinite character of service that demand cannot be stated with details ordinarily given in an annual financial statement. To make an exceptional grant which forms no part of current service of any financial year, and legislature of a state shall have power to authorize by law withdrawal of monies from consolidated fund of state for purposes for which said grants are made. Article continues. Provisions of Article 203 and 204 shall have effect in relation to making of any grant under Clause 1 and to any law to be made under that clause as they have effect in relation to making of a grant with regard to any expenditure mentioned in annual financial statement and law to be made for authorizations of appropriation of monies out of consolidated fund of state to meet such expenditure. Article 2071. Special provisions as to financial bills. A bill or amendment making provisions for any of matters specified in subclause A to F of clause 1 of Article 199 shall not be introduced or moved except on recommendations of governor, and a bill making such provisions shall not be introduced in Legislative Council, provided that no recommendation shall be required under this clause for moving of an amendment making provisions for reduction or abolition of any tax. A bill of amendment shall not be deemed to make provisions for any of matters aforesaid by reasons only that it provides for imposition of fines or other pecuniary penalties, or for demand or payment of fees for licenses or fees for services rendered, or by reasons that it provides for imposition, abolition, remissions, alterations, or regulations of any tax or tax by any local authority or party for local purpose. A bill which, if enacted and brought into operation, would involve expenditure from consolidated fund of a state shall not be passed by House of Legislature of state unless governor has recommended to that house or consideration of bill. Procedure generally. 208. Article 201. A House of Legislature of a state may make rules for regulating, subject to provisions of this Constitution, its procedures and conduct of its business. 2. Until rules are made under Clause 1, rules of procedures and standing orders in force immediately before commencement of this Constitution with respect to legislature for corresponding provinces shall have effect in relation to legislature of the state, subject to such modifications and adaptations as may be made therein by a Speaker of Legislative Assembly or Chairman of Legislative Council, as case may be. 3. In a state having Legislative Council, governors, after consultation with the Speaker of Legislative Assembly and Chairman of Legislative Council, may make rules as to procedures with respect to communications between two houses. 209 Article. 209 Regulation by law of procedures to legislature of a state in relation to financial business. Legislature of a state may, for purpose of a timely completion of financial business, regulate by law procedures and conduct of business in houses of legislature of a state in relation to any financial matter or to any bill for appropriation of monies out of consolidated fund of state. And if and so far as any provision of any law so made is inconsistent with any rule made by House or either House or Legislature of a state under clause 1 of Article 208 or with any rule or standing order having effect of relation to legislature of state under clause 2 of that article, such provision shall prevail. Language to be used in legislature 2101. Notwithstanding anything in part 17, but subject to provisions of Article 348, business in legislature of a state shall be translated in official language or languages of state or in Hindi or in English. Provided that Speaker of Legislative Assembly or Chairman of Legislative Council or person acting as such as case may be, may permit any member who cannot adequately express himself in any of the languages aforesaid or to address House in his mother tongue. Unless the legislature of a state by law otherwise provides, this article shall, after expiration of a period of 15 years from commencement of constitution, have effect as if words or in English were omitted therefrom. Provided that in relation to legislatures of states of Himachal Pradesh, Manipur, Meghalaya and Tripura, this law shall have effect as if for words 15 years occurrence therein, words 25 years were substituted. Provided further that in relation to legislature of states or Arunachal Pradesh, Goa and Mizoram, this clause shall have effect as if for words 15 years occurring therein, words 40 years were substituted. Article 211. No discussion shall take place in the legislature of a state with respect to conduct of any judge of Supreme Court or of High Court in discharge of duties. 212.1. Validity of any proceedings in legislature of a state shall not be called in question on ground of any alleged irregularities and procedures. No. 2. No offer or member of legislature of a state in whom powers are vested by or under Constitution for regulating procedures or conduct of business or for maintaining order in legislature shall be subject to the jurisdiction of any court in respect of exercise by him those powers. Chapter 5. Legislative power of governor. 213. If at any time except when legislative assembly of a state is in session or where there is a legislative council in a state except when both houses of legislature are in session of governor is satisfied that circumstances exist which render it necessary for him to take immediate action, he may promulgate such ordinances as circumstances appear to him to require. Provided that governor shall not without instructions from president promulgate any such ordinance. If a bill containing same provisions would under this constitution have required previous sanction of president for introduction thereof into legislature, or he would have deemed it necessary to reserve a bill containing same provisions for consideration of president, or an act of legislature of a state containing same provisions would under this constitution have been invalid unless, having been preserved for consideration of president, it had received assent of president. An ordinance promulgated under this article shall have same force and effect as an act of legislature of state assented to by governor, but every such ordinance shall be laid before legislative assembly of a state or where there is legislative council in a state before both houses, and shall cease to operate at expiration of 6 weeks from assembly of legislature, or if before expiration of that period is resolution disapproving it is passed by legislative assembly and agreed to the legislative council, if any, upon passing of resolution, or as case may be on resolution being agreed to by council, and may be withdrawn at any time by governor of a state having a legislative council, are summoned to reassemble on different dates. Period of 6 weeks shall be reckoned from later of those states for purpose of this clause. If and so far as an ordinance under this article makes any provision which would not be valid if enacted in an act of a legislature of a state assent to by governor, it shall be void. Provided that for purposes of provisions of this constitution relating to this effect of an act of legislature of a state which is repugnant to an act of parliament or an existing law with respect to a matter enumerated in concurrent list, an ordinance promulgated under this article in pursuing of instructions from President shall be deemed to be an act of legislature of state which has been reserved for consideration of President and assented to by him. So this was about the state, and we had to understand